Good afternoon. I've been asked to give you a taster session to give you an idea, a little bit of how law works. And what I want to do is essentially tell you a bit of a story. Because most of the law cases that you read, most of the law you'll be studying, will give you certain facts and certain scenarios. And your job is to understand how that scenario works, how the law applies to that scenario, and also take a step back and ask yourself, should the law have decided the case in that way? And most of our cases, most of our understandings start with ordinary people in ordinary relationships with others, and something goes a bit wrong, and the law is asked to step in and do something about that particular situation. And the situation we're looking at today is an employment relationship that went wrong. Miss Benkebush was employed as a cook in an embassy. So far, so good. She's got her job. She's enjoying doing her work. She's got her employment going. It's a very happy situation. But things start to go a bit wrong. And she's concerned she's being asked to do too many hours. And so she thinks the hours she's been asked to do are unfair. She also thinks she's not being paid the money she should be being paid for her job. So she starts to be concerned about this employment relationship. Eventually, she is dismissed from her job, and she argues that she has been unfairly dismissed. So she wants to go to the court, she wants to bring an action, and she wants to say, look, this situation has gone wrong. I've not been paid the money I should have been paid. I've been working too many hours. I've been unfairly dismissed. I want to go to court to protect my rights and get some form of compensation or even get my job back. But she's in a difficult situation. And the reason she's in a difficult situation is because she's being employed by an embassy. And you might think, well, what difference does that make? And the difference comes from that piece of legislation I've mentioned up there on the slide. Because we have a State Immunity Act 1978. And this is set up to recognize that different countries have different embassies in other countries, and they need to be regulated differently. And these embassies get certain immunities from legal actions. And this particular piece of legislation had been interpreted to give what we call a blanket immunity to certain types of employment contracts. And that included employment contracts of people working in certain positions in embassies, and that included cooks. So she's stuck. She thinks that she should be able to rely on exactly the same kind of law as if she was employed by, say, Oxford University or one of the colleges and working in their kitchens. And then she'd be able to go to court and say, look, you've not been treating me correctly, I want to protect my rights. But because she's working in an embassy, the legislation says, no, there's immunity. You can't go to court and say your rights have been breached because they have an immunity in these situations. It doesn't matter if they've broken the employment relationship contract. It doesn't matter if they've made you work too many hours or if they've not paid you correctly, because they have immunity. So you might think, okay, that's the end of the story. Very sad tale. She can't go away and protect her employment rights. But there's more to it than that, because there's other legislation in play. And one piece of legislation that's in play is the Human Rights Act 1998. Now, this act is the main way in which we incorporate human rights into UK law. It's not the only protection of human rights, but it's the main way in which we protect those rights. And this incorporates the European Convention of Human Rights into English law. And Section 1 of the Act tells us what these convention rights are. And then they're all set out in Schedule 1 to the Act. So Ms. Benkebush's lawyers go away and they say, is there something in the Human Rights Act that might help us here? And they find Article 6. And Article 6 is the right to a fair hearing. Now, normally when we think about Article 6, we think about situations when you have, say, you've applied for an Oxford University place, say, I don't know, maybe some of you are thinking of doing that, and you apply and you come up for an interview and you don't get the place and you think, Was there something a bit wrong in that decision? Can I go to a tribunal? Can I have a right to a fair hearing and represent myself and say, I should have a hearing here, I should have a say? Or if you come to Oxford and we give you a place and you, I don't know, perhaps don't do the work you should be doing, and we decide to have a decision and say, you know, we've had enough of this student, we're going to send them down, they're going away, you would say, I have a right to a fair hearing, I have a right to put my side of the case. And that's what we normally think about when we think of a right to a fair hearing. But it also includes the right to get to court. So it includes your ability to go to court and say, look, I think I have some rights here, but I'm not able to go to court and argue that you should protect my rights because there's this blanket immunity that's just stopping me get to court to even say that I have some rights in the situation. I can't even argue that maybe there should be an exception to this immunity in my case. So my rights are being breached. I should be able to get to court. And the Court of Appeal, when they heard this argument, said, yes, you're right. Article 6 has been breached. You should have been given the chance to go to court and say, perhaps this immunity doesn't apply in my employment situation. Great. Miss Benkebush has a right. Fantastic. But a right is only as good as your remedy. So what's her remedy? What can you do to protect her right in this case? And that's where Section 3 of the Act comes in. And Section 3 says, OK, courts, so far as it is possible to do so, you have to read legislation like the State Immunity Act and give effect in a way which is compatible with convention rights. So what does that mean? Well, that means the court has to look at the provisions of the State Immunity Act and say, can I in some way interpret this or read it or give it an effect that protects Ms. Benkebush's right to have a fair hearing? And often what we'll do in those scenarios is we might have a broad word. And we might say, well, can we interpret this to only apply in certain situations? So we might read something down, or sometimes we'll read words in. But there's only so much you can do. And when the court looked at the State Immunity Act, they said, well, we can't really read things here. You're essentially saying, this is a blanket ban. You cannot come to court. For us to read that as a way of getting you to come to court wouldn't be reading. That would be a contradiction. It would be like saying no means yes. That's going too far. That's not really possible. We can't read it in that way. So if that's the case, what can the court do? Well, along comes Section 4. And in these scenarios, the court can say, well, I can't read this legislation so as to allow you to get to court. So instead, what I can do is issue what we call a declaration of incompatibility. I can declare that this piece of legislation is incompatible with your human right. Great, but what does that mean? Well, we're told that any declaration of incompatibility does not affect the validity, the continuing operation, or the enforcement of legislation. In other words, you have a piece of legislation, it has a little notice saying, I'm incompatible with the Human Rights Act, but it's still there, it's still in force. Miss Benkebush can't do anything about it. She might go home thinking, isn't it great that the courts have told me that this piece of legislation is incompatible with, I feel so validified now. I feel so much better knowing that it's incompatible with human rights. I still can't get my employment contract sorted out and I'm still unemployed and I don't have any remedy or damages, but I feel so much better now. The reason we do this is because we have a system of parliamentary legislative supremacy. And we say Parliament should have the final say, not the courts. So it's not for the courts to strike down a piece of legislation. It's for the courts to say, look, this looks as though it's incompatible with convention rights. So Parliament, you should do something about it. And it's for Parliament to then decide if, and if so, how, it's going to do something about that situation. So as lawyers, we have to think, is that the way in which we should be protecting human rights in this situation? But for Miss Benkebush, that's not the end of the story. because she doesn't just have the Human Rights Act. She's also got European Union law. Okay, what difference does this make? Well, I said that the Human Rights Act is the main way of protecting human rights in English law, but it's not the only way. We also use the common law, and there are also sometimes occasions in which European Union law can help protect your rights. But it only applies when you are within the scope of European Union law, which is a fantastic lawyerly phrase. It's a brilliant lawyerly phrase because scope means how you then interpret it in the case law as to what scope means. And what we do know is you are within the scope of European Union law when you are a national state that is implementing an aspect of European Union law. Okay, so how does that work? Well, I told you that Miss Benkebush thought she was being asked to work too many hours. And she said this breached the working time regulations. Well, these working time regulations are pieces of delegated UK legislation that were brought in to implement a piece of European Union law, the Working Time Directive. So the European Union enacts a directive for a particular aim to minimise working hours and regulate how many hours you're working in certain jobs. And the UK then enacts a measure to implement that piece of European Union law. So because that regulation implements an EU obligation, Ms. Benkebush is within the scope of European Union law. And once she's within the scope of European Union law, she can't just rely on European Union law, she also gets to rely on general principles of European Union law and the European Union's Charter of Fundamental Rights and Freedoms. So in a roundabout way, she's been able to rely on human rights that come from the European Union and not just human rights that come from UK law. And the general principles of European Union law replicate the Convention, including Article 6 and the right to a fair hearing. So she can rely on the same provision. It also has Article 47, which looks at the right to an effective remedy. And that includes the ability to get to court and to plead your case and to get a remedy in certain situations. How does that make a difference to Ms. Benkebush? The reason it makes a difference is because of the way in which we have incorporated European Union law into UK law. And this comes from the European Communities Act 1972. And incorporates another great lawyerly phrase, the primacy of directly effective European Union law, which is lawyerly shorthand for saying European Union law can create rights and obligations that you can rely on in national courts. That's what we mean by direct effect. You can rely on these European Union law rights in your national courts. When we talk about primacy, it means these provisions are able to override domestic law. And the way in which we do that in UK law is it allows you to disapply law that contradicts directly effective provisions of European Union law. In this case, to disapply a piece of legislation. Now, if my very bad skills have worked out, this diagram will hopefully, or this series of lines will hopefully show you how that works. So we've ended up with an employment contract between Miss Benkebush and the embassy. She thinks it's been breached, she wants to do something about it. But when she tried to do something about it, she was told the State Immunity Act gives blanket immunity in these particular situations. So you just can't get to court. But Miss Benkebush was able to say, but I am within the scope of European Union law, which includes the Working Time Directive. This has been incorporated into English law through the European Communities Act 1972. And it includes the Charter, which will give me this right to get to court and plead my case. And because of this, that State Immunity Act has been disapplied. It's no longer there. And because it's no longer there in this particular situation, Miss Benkebush can now go to court and say, right, that working time directive you've breached, those minimum wages you've breached, I want an argument to say that in this particular situation, these laws should apply. It doesn't mean to say she's won the case yet. All she's won is the ability to go to court and say that now there's a chance for us to have a hearing to work out whether you have breached my rights in these situations and whether these rights should apply to me. Why am I talking you through this, or why am I making you think about this particular case? And the reason I'm trying to talk you through this particular case is because it gives you an idea, partly of what we do in law, but also it gets you to think about the questions we ask on the law course, the kind of questions you'll be asked to think about. You'll be told to go away and read this case. You'll be asked to go away and think about it and to understand how it works. And sometimes that can be quite complicated. And sometimes you're thinking not just about, do I have a right, but also, do I have an effective remedy to protect that right? Sometimes you might be thinking not just about, do I have a right, but can I get to court? And if so, how do I get to court in this particular scenario? So it's not just thinking about the rights that you have, it's also about how you get to court, how you protect them, whether you have an effective remedy for those particular rights. But we also like to take a step back and think about what this is telling us about what's going on in society at the moment. And for me as a constitutional lawyer, that means how our constitution is working in particular scenarios. Now, unless you've been hiding somewhere, and I'm not quite sure where you would have managed to hide to avoid this, but you may have heard about Brexit, okay? Anyone here not heard about Brexit? Yeah, thought as much. Excellent. So you've all not, if anyone had not heard of it, I think I'd say to you, where was your hiding place? And please, can I go there? Because I think it would be nice not to hear about Brexit for a few weeks. It would be very nice. I even went to Australia and still got asked about Brexit. This is not on. So I need to find the hiding place. But the reason Brexit is so controversial is because of this clash of sovereignties. Because we are not used to this idea that principles can override democratic legislation. You saw that in the way in which we looked at the Human Rights Act and the way in which you looked at European Union law. You can interpret laws to protect convention rights. You can declare laws incompatible if they don't protect your convention rights, but you can't disapply them. You can't strike them down. But if you're using European Union law, you can disapply legislation. And that takes some of the decision-making power away from Parliament. And so you get a disagreement about whether that is legitimate or not. Is it legitimate because this is a sovereign Parliament transferring power to another organisation to try and achieve greater goods and benefits that you might not be able to achieve in one particular country? Or is this an illegitimate transfer of power away from a democratically accountable body to a body that seems distant, doesn't seem to take account of what's going on in different countries, and might not be seen to be as democratic as a UK Parliament? As a lawyer, you have to think about those questions. You have to think about it not in terms of political, polemical arguments. You have to think about it in terms of what are the powers? How does it work? Do I think this is a good or bad aim? Is it taking democracy away? How do I evaluate that? What do you mean by democracy? Those questions are what you have to ask yourself to be able to answer these particular issues. And you need to do it being aware of how the law works. And having that awareness helps you to think about how we structure our particular constitution. It also raises issues about how we protect human rights. So you need to take a step back and say, well, we have parliamentary sovereignty. So in these scenarios, we can declare legislation incompatible, but we can't strike it down. That makes us quite unique amongst other constitutions. So if you went to the US and said, I have a constitutional right, then that means something very different. In the US, it means you can go to a court and legislation that contravenes that constitutional right can be struck down. If you did the same thing in Germany, exactly the same would happen, but not here. So we have to ask ourselves why. Why have we decided to protect rights in a different way? And that's because we are thinking about whether rights are more important than democratic decision making, or whether democratic solutions are more important than rights. And that might get you thinking about, well, if we are going to protect these rights, which ones should we be protecting? Should we protect things like the right to life? But what about the right to a job or the right to a house? Should they be protected in exactly the same way? Which means you have to take a step back and think about what is different about these different types of rights. We've been talking in this scenario about employment rights, but the human right that was being protected was your access to court, not your employment right. So there are different rights that could apply in different scenarios, and you might want to protect them to a different extent. Another issue that this raises a bigger picture is how should we deal with referendums in the UK? They're quite a new phenomenon. You have a specific question that's been asked. So you have to ask yourself, does a decision by a referendum, is that more legitimate because that is direct democracy on a specific question? So it should have more force, more validity than an act of parliament. But then you also might want to take a step back and say, but do we also have a responsibility to make sure when we have referendums that we've thought beforehand about what we do to the outcome of a referendum or not? And do we have a responsibility when we hold a referendum to make sure that those taking this decision are properly, fully informed? And I'm sure you've got a whole range of opinions in the audience as to how you feel on those questions. It's not my job to tell you what the answer is. It's my job here as a law professor to get you to think about it, to give you the information that helps you to think about it, and to help you develop your arguments in response to these kinds of issues. It's not just raising issues about constitutional law, it's also raising issues about labour law. So we've been talking about a contract of employment. And normally when we talk about contracts, we allow people to have contractual freedom. So we allow you to enter into contracts that you have negotiated with somebody else. But when it comes to labour law, we tend to regulate those types of contracts more than other contracts. Why is that? And the justification that's often given is the importance of you having work and also an inequality of bargaining power. Often employers have more bargaining power than employees. So we have to ask ourselves in that scenario, should the law step in and regulate that situation? And if so, how does it get the right balance? How does it protect the rights of employees whilst also recognizing that if you have too much regulation, you might stop people from forming businesses, from taking up enterprise and employing people in the first place? Where do you draw the line? How do you balance it to make sure you have a good working economy whilst protecting rights and making sure individuals are not exploited? We also talked about immunities. So you have to think about, should an embassy have an immunity from employment law? Or should it only really have immunity from other things that are more connected to its role as an embassy? Does it really need immunity when it's employing chefs or cleaners or gardeners? Or does it make a difference if it's a chef or a cleaner or a gardener? Are they performing different roles? You also have to think about whether it would make a difference about what you're immunizing yourself against. Does it make a difference if you're saying, well, it's okay, I can make a chef work 80 hours a week, that's not a problem? Would it make a difference if you were discriminating against that chef? I've told you about Miss Benkebush's situation. There's another applicant in the case, Jana, and she was arguing sexual harassment and discrimination against women, not at the Sudanese embassy, in case you're worrying about that, but this was the Libyan embassy, so she was employed by a different embassy. But that raises a question. Do we want to say, well, yes, you can have immunity for things like employment hours, but not when it comes to sexual harassment or racial harassment or discrimination, because those are more important we won't allow you to discriminate when you're employing in this country. Or do we say, no, it's exactly the same as employment. If you have immunity for working time, you also have immunity for discrimination issues. What I'm hoping to show you through this taster lecture is what law is about. You start off with a scenario. You start off with individuals. You have different situations. You have laws that regulate that particular situation. Your job is not just to understand what the law says and to understand how it fits in with other laws and regulations. Your job is also to take a step back and ask yourself, why? And to think about that why question specifically. Why is it there is immunity for this employment contract, but also more generally, what is this telling us about our Constitution? What is this telling us about the relationship between UK law and European Union law? What is this telling us about how we protect human rights? Do I agree with those protections? Now, I also chose this case for another reason, and that's because you can follow it. And the reason you can follow it is because the case I've just described was decided in the Court of Appeal. So up there, and I think this is going online, isn't it, afterwards? So this will be online. You can go away and have a look at it and see these references. So the first reference is to the decision of the Court of Appeal. You can go away, you can read it, you can see how it was argued, and you can see how they reached their conclusion. Below that, this has been argued in June before the Supreme Court. So we don't know the answer yet, fully. We know what the Court of Appeal decided, but we don't know what the Supreme Court is going to decide. So you can go online and you can watch barristers arguing this case in the Supreme Court. And then you can take a step back and say, okay, if I was a judge, who do I think should win and why? And because it was argued in June, it's likely to be starting appearing sometime between now and December. So you can keep an eye on the Supreme Court page and you can find the decision when it's decided, read how the court's decided and say, okay, what do I think about this? Do I agree? What is this telling me about these other issues? Would I have decided the same way as the Supreme Court? And because academics aren't very quiet, we tend to blog about things. So underneath, I've given you a reference to the UK CLA blog. And the UK CLA blog has become quite prevalent. There's lots on there. If you were unable to hide from Brexit, you were probably unable to hide from the blog because it was constantly posting things about the Miller decision. So you can go away and you can read for free commentary of academics about what is going on in these areas of the law. See why we're arguing, see what we're disagreeing about, and take something away about it. If you're interested in human rights, the link below is to the Oxford Human Rights Hub website, which gives lots of interesting blog posts about what's going on in human rights, including in labour law and employment law rights, not just in the UK, but globally. So I'm hoping by talking you through this case and giving you these references, I've given you an idea of why I personally think law is really exciting. You might think it is a lot of sitting in a library and reading lots and lots of books, and it is. Sorry, I can't lie to you. It will be a lot of time, not in a library anymore. That was for ancient people like me. More online, scrolling down cases, taking notes, and understanding. It will involve a lot of reasoning, a lot of reading. But it's exciting, it's interesting, it raises a huge amounts of issues, and our job is to teach you how to think, how to reason, and how to argue about the information that you read. And thank you very much for listening.